village incident, one of the 12 main incidents referred to earlier. The office also let it be known that there will be additional courts-martial if further incriminating evidence is brought up by the Independent Commission of Inquiry. The ICOE is an independent special investigation procedure established for Rakhine allegations by the President of Myanmar, chaired by a former Deputy Minister from the Philippines, with 3 other members, including a former Under-Secretary General of the United Nations from Japan. On 26 November 2019, this commission announced that it had taken about 1,500 witness statements from all affected groups in Rakhine, and that it has interviewed 29 military personnel who were deployed to the affected townships in northern Rakhine during the military operations from 25th August 2017 to 5th September 2017, as well as 20 police personnel who were stationed at the police posts that were attacked on 25th August 2017. There is currently no other fact-finding body in the world that has garnered relevant first-hand information on what occurred in Rakhine in 2017 to the same extent as the Independent Commission of Inquiry and the Office of the Judge Advocate General in Myanmar. This fact reinforces my sense that I should refrain from any action or statement that could undermine the integrity of these ongoing criminal justice processes in Myanmar. They must be allowed to run their course. It is never easy for armed forces to recognize self-interest in accountability for their members and to implement a will to accountability through actual investigations and prosecutions. I respectfully invite the members of the court to consider for a moment the record of other countries. This is a common challenge, even in resource-rich countries. Recent cases in the news headlines illustrate that even when military justice works, there can be reversals. This can also happen in Myanmar. As part of the overall efforts of the Myanmar government to provide justice, a court-martial found that 10 Muslim men had been summarily executed in Indian Village, one of the 12 locations of serious incidents referred to earlier. It sentenced 4 officers and 3 soldiers, each to 10 years in prison with hard labor. After serving a part of their sentences, they were given a military pardon. Many of us in Myanmar were unhappy with this pardon. Other cases are undertaken without controversy. For example, in the Mansi case, a court-martial sat close to the location in Kachin State where 3 internally displaced civilians had been killed. It sentenced 6 soldiers, each to 10 years in prison, in January 2018. Relatives of the victims and local civil society representatives were invited to the proceedings. The Office of the Judge Advocate General in Myanmar is, by our standards, well-resourced, with more than 90 staff and a presence in all regional commands throughout the country. I'm encouraged by the Gutabiem court-martial, and I expect the office to continue its investigations and prosecutions based on reliable evidence gathered in Rakhine and from persons who witnessed what happened there. Can there be genocidal intent on the part of a state that actively investigates, prosecutes, and punishes soldiers and officers who are accused of wrongdoing? Although the focus here is on members of the military, I can assure you that appropriate action will also be taken against civilian offenders in line with due process. There will be no tolerance of human rights violations in the Rakhine or elsewhere in Myanmar. Mr. President, there are those who wish to externalize accountability for alleged war by the Gambia, have even suggested that there cannot be accountability through Myanmar's military justice system. This not only contradicts Article 20B of the Constitution of Myanmar, it undercuts painstaking domestic efforts relevant to the establishing of cooperation between the military and the civilian government in Myanmar in the context of a constitution that needs to be amended to complete the process of democratization. That process is now underway at the Piramzu Hluttaw, the Union Parliament. The emerging system of international criminal justice rests on the principle of complementarity. Accountability through domestic criminal justice is the norm. Only if domestic accountability fails may international justice come into play. It would be inconsistent with complementarity to require that domestic criminal justice should proceed much faster than international criminal justice. A rush to externalize accountability may undermine professionals in domestic criminal justice agencies. What does the appearance of competition between domestic and international accountability do to the public's trust in the intentions of impatient international actors? No stone should be left unturned to make domestic accountability work. It would not be helpful for the international legal order if the impression takes hold that only resource-rich countries can conduct adequate domestic investigations and prosecutions, and that the domestic justice of countries still striving to cope with the burden of unhappy legacies and present challenges cannot be made good enough. The Gambia will also understand this challenge with which they too are confronted. Mr. President and members of the Court, these reflections are relevant to the present hearing because the applicant has brought a case based on the Genocide Convention. We are, however, dealing with an internal armed conflict started by coordinated and comprehensive attacks by the Arakan Rohingya Salvation Army, ARSA, to which Myanmar's defense services responded. Tragically, this armed conflict led to the exodus of several 100,000 Muslims from the three northernmost townships of Rakhine into Bangladesh, just as the armed conflict in Croatia, with which the court had to deal, led to the massive exodus of, first, ethnic Croats and later ethnic Serbs. As I've already stated, if war crimes have been committed by members of Myanmar's defense services, they will be prosecuted through our military justice system in accordance with Myanmar's constitution. It is a matter for the competent criminal justice authorities to assess whether, for example, there had been inadequate distinction between civilians and ARSA fighters, disproportionate use of force, violations of human rights, failure to prevent plundering of property or destruction, or acts of forcible displacement of civilians. Such conduct, if proven, could be relevant under international humanitarian law or human rights conventions, but not under the 1948 Genocide Convention, for reasons on which Professor William Chabas will elaborate in a moment. Mr. President, allow me to share one further reflection in this great hall of justice. International law may well be our only global value system, and international justice a practice that affirms our common values. Leaders of states and relevant intergovernmental and non-governmental organizations should also be cognizant of their responsibility to express and affirm fundamental values. Feeding the flames of an extreme polarization in the context of Rakhine, for example, can harm the values of peace and harmony in Myanmar. Aggravating the wounds of conflict can undermine unity in Rakhine. Hate narratives are not simply confined to hate speech. Language that contributes to extreme polarization also amounts to hate narratives. Several international actors face a challenge here. But Myanmar also could have done more since the 1980s to emphasize the shared heritage and deeper layers of unity among the diverse peoples of our country. Cycles of intercommunal violence in Rakhine, going back to the 1940s, should be countered not just by practical measures aimed at sustainable development and rule of law, but also by nourishing a spiritual mindset of unity. It is a moral responsibility of leaders to guard the aspirations of people for harmony and peace. U Thant, the third United Nations Secretary General, had understood this. He wrote in his memoirs, View from the UN, published in 1974, "I even believe that the mark of the truly educated and imaginative person facing the 21st century is that he feels himself to be a planetary citizen." Encouraging this added layer of identity, a sense of planetary citizenship, is of fundamental importance for peaceful relations between nations, as well as between ethnic and religious groups. A commitment to broadening the mindset must go hand in hand with practical steps to improve lives. Even before the events of 2016 to 2017, Muslim, Buddhist, and other communities in Rakhine faced what the Kofi Annan Advisory Commission described as complex challenges of low development and poverty rooted in enduring social conflict between the communities. The Myanmar government is committed to addressing these challenges. Together with our partners, we are now striving to ensure that all communities enjoy the same fundamental rights. To expedite citizenship verification and application, a mobile team is already in operation. All children born in Rakhine, regardless of religious background, are issued with birth certificates. Arrangements have been made to enable more Muslim youth to attend classes at universities across Myanmar. With the support of international and local partners, scholarships will also be made available to students from all communities living in Rakhine. The government has started a social cohesion model project in Maungdaw Township to promote social harmony among all communities. Interfaith fora have been encouraged. These are some of the steps taken to improve livelihoods, security, access to education and health, citizenship, and social cohesion for all communities in Rakhine. 3 IDP camps have already been closed, and an IDP camp closure strategy has been adopted. Myanmar is also committed to the voluntary, safe, and dignified repatriation of displaced persons from Rakhine under the framework agreement reached between Bangladesh and Myanmar. Mr. President, how can there be an ongoing genocide or genocidal intent when these concrete steps are being taken in Rakhine? To conclude, Mr. President and members of the court, Rakhine today suffers an internal armed conflict between the Buddhist Arakan Army and Myanmar's defense services. Muslims are not a party to this conflict, but may, like other civilians in the conflict area, be affected by security measures that are in place. We pray the court to refrain from taking any action that might aggravate the ongoing conflict, armed conflict, and peace and security in Rakhine. Right now, in northern Rakhine, an army base near Palewa is under attack by a group of more than 400 Arakan army fighters, and some 200 insurgents have surrounded a military column near An City in Rakhine. Since Myanmar gained independence in 1948, our people have not known the security of sustainable development that is a fruit of peace and prosperity. Our greatest challenge is to address the roots of distrust and fear, prejudice and hate that undermine the foundations of our union. We shall adhere steadfastly to our commitment to nonviolence, human rights, national reconciliation, and rule of law as we go forward to build the democratic federal union to which our people have aspired for generations past. We look to justice as a champion of the reconciliation and harmony that will assure the security and rights of all peoples. Mr. President and members of the court, I thank you for your kind attention, and I ask that you now call upon Professor William Schabas to continue the Myanmar submissions.